Thank you. We're going to take a step back in abstraction and look at the rules of the game that we affectionately know as administrative law. The Administrative Procedure Act, in theory, limits agency power. I'll talk about how these statutory limitations often prove flimsy in practice and how agencies can collaborate with advocacy groups to avoid them entirely. My colleague Adam White will discuss the judge-made deference doctrines that allow agencies to stretch their statutory constraints to the breaking point. And Boyd and Gray will address agency intimidation that thwarts would-be challengers of regulations and the crony capitalist policies that co-opt major industry players. So, what are the limitations on agency power and how much do they actually constrain agency action? To have the force of law, a rule must be preceded by notice and an opportunity for public comment. And the agency, as you've heard, must respond to significant comments before finalizing the rule. But agencies are clever, and they know how to throw their weight around without going through the trouble of notice and comment rulemaking. So-called interpretive rules that merely tell how the agency interprets a statute or rule without actually creating legal duties are said to lack the force of law. Even so, courts give them a degree of deference, as Adam White will explain. Just last month, the Supreme Court held that these so-called interpretive rules do not require notice and comment, even when they alter a prior interpretation on which the regulated community has long relied. And agencies aren't limited to prospective rulemaking. They can act through retrospective adjudication as well. And although orders technically apply only to the party before the agency, rules and orders can have practically the same effect on the regulated industry. Statutory deadlines provide another theoretical limit on agency power, but judicial precedent has weakened their force. The U.S. Court of Appeals for the D.C. Circuit, where two of us clerked, now condones retroactive rules to make up for missed deadlines, despite the general principle that retroactive rulemaking or legislation is forbidden, absent express congressional authority. As my former boss, Judge Janice Rogers Brown, observed in dissent, allowing retroactive regulation after the expiration of a statutory deadline lets agencies like EPA get away with violating explicit congressional time limits, creates perverse incentives, rewards dilatoriness, and makes regulatory burdens even less predictable. In addition to providing notice and abiding by deadlines, agencies are traditionally required to promulgate rules whose benefits outweigh their costs. When this requirement is included in a statute, it allows the reviewing court to ensure that the agency's cost-benefit analysis is reasonable and that the rule does more good than harm. For example, as Hester mentioned, the SEC's proxy rule was vacated because the agency, quote, inconsistently and opportunistically framed the costs and benefits of the rule and failed to adequately quantify certain costs. That's all well and good for statutes that require cost-benefit analysis, but as you've also heard, many other statutes that authorize rulemaking do not include an explicit cost-benefit requirement. In such cases, agencies are constrained only by executive orders, mandating efficient regulation, and by cost-benefit review in the Office of Management and Budget. But these executive branch requirements are not currently judicially reviewable and thus offer no external check on the administrative state. Finally, agencies must satisfy the Administrative Procedure Act's standards of judicial review. Under the APA, a court must set aside rules that are arbitrary and capricious, but that gives agencies a lot of leeway. Courts will only hold that a rule is arbitrary and capricious in egregious circumstances. For example, when the agency fails to consider an important aspect of the problem, to give a reasoned account of its decision, to consider responsible alternatives to its chosen policy, or to give reasoned responses to all significant comments. Or when the rule is based upon an erroneous factual premise or contains requirements that are logically impossible to satisfy or undercut the agency's own purported goals. We do occasionally see cases that fail to clear even this relatively low threshold. For example, we're now challenging an EPA rule that purports to allow automakers to ask EPA for a new test fuel on which to certify new models of automobiles. But that rule contains a commercial availability requirement that's categorically impossible to satisfy, and thus renders the rule useless. But it's not usually that hard for an agency to come up with a satisfactory justification for its rules. And as Adam will explain, courts tend to defer to those explanations. The APA also requires that an agency's factual findings be supported by substantial evidence. But substantial evidence doesn't mean best evidence. And the courts have held that substantial evidence is such relevant evidence as a reasonable mind might accept as adequate to support a conclusion. That standard, quote, requires more than a scintilla, but less than a preponderance of the evidence. It means the court doesn't have to agree with the agency that it's more likely than not that that evidence is correct. Thus, an agency need only, quote, specify the evidence on which it relied and explain how that evidence supports the conclusion it reached. Courts won't second guess an agency's decision to assign a greater weight to some pieces of evidence over others. Agencies also have an advantage when it comes to judicial remedies. Although the APA requires a court to, quote, hold unlawful and set aside a rule that is arbitrary and capricious or unsupported by substantial evidence, under judge-made doctrines, courts often give agencies the benefit of the doubt and simply remand rules that fail to meet the APA's standard. That means that the unlawful rule remains in place while the agency is fixing it and continues to impact the regulated industry. Instead of seriously constraining agency action, judicial review has too often become a tool for even greater agency power. How does that work? Oftentimes, an agency like EPA allows itself to be hauled into court for failing to regulate and then quickly consents to a privately negotiated court order that accomplishes the agency's own political goals, free of little inconveniences like notice and comment, cooperative federalism, where states are entitled to have a say, statutory limits on agency power, congressional priorities, and cost-benefit review by OMB. All of this is done with a wink and a nod to the petitioner, which is often an advocacy organization that employs former agency employees. I like to think of Chewbacca escorted in handcuffs by Han Solo and Luke Skywalker in stormtrooper garb. Everyone is in on the game. This sue and settle technique is common because it's shockingly effective. Citizen suit provisions in environmental statutes give activists a profitable mechanism for suing EPA when the agency misses a deadline, as it frequently does. Then EPA will happily agree to a new deadline for promulgating the overdue regulations. That court-ordered deadline frees EPA to disregard other statutory obligations, congressional priorities, and the input of interested third parties. The impact of sue and settle rulemaking is significant. More than 70 lawsuits against federal agencies have been settled with consent decrees ordering rulemaking under the current administration, and of those, 25 economically significant rules have a combined price tag of $164 billion with a B. If that's not bad enough, Adam will now talk about how judicial deference further expands agency power beyond the scope of the APA.
Thanks. I noticed just as we started that they carted the coffee out of the room, and so we're tasked now with trying to explain administrative law and judicial deference without any caffeine, so I'll still try to keep it light. Like Adam said, I'll talk about judicial deference to agency interpretations. Two separate issues. One is the deference an agency gets when they're interpreting a statute, and the other is the deference that an agency gets in interpreting their own regulations. And so I'll be giving you the bad news and then the worse news. We'll start with statutory interpretation. The basic standard, as Hester noted in the last discussion, is what's called Chevron Deference. This is how it works. If an agency interprets a statute and the case goes to court, the court basically asks two questions. One, is the statute so clear, so unambiguous, that there's really only one possible meaning that the statute could have? If so, that's the end of it. The court reads the statute for itself, applies the statute, you don't get to any deference. But that's really the exception more than the rule, because more often than not, agency statutes aren't written in the clearest terms. A line that Chief Justice Roberts used a couple of years ago, he said, "Congressional delegations to agencies are often ambiguous, expressing a mood rather than a message." There's plenty of room in there for the agencies to creatively interpret the statute. So if the statute's not unambiguous, if it's susceptible to a variety of readings, the court will defer to the agency's interpretation so long as the interpretation is reasonable. That's a relatively low bar. I mean, much like Adam said, that substantial evidence doesn't mean the best evidence, it just means some evidence. A reasonable interpretation isn't necessarily the best of several interpretations. It's just simply a reasonable one. Furthermore, as the Supreme Court established a couple of years ago, the agencies get the same deference when they're interpreting the statutes defining the agency's own jurisdiction, right? The challengers in that case argued that agencies shouldn't get any deference when they're interpreting the bounds of their own authority, because obviously the agency is going to aggressively interpret those bounds. But the court said no, it's still Chevron deference. Furthermore, if an agency interprets the statute one way, years later, a new administration decides to reverse course, the agency has pretty broad leeway to do so. That's a doctrine called Brand X. And so again, the basic standard is Chevron. If the statute's ambiguous, susceptible to multiple meanings, then the agency gets deference for a reasonable interpretation. When an agency is interpreting one of its own regulations, not a statute, they get even more deference. The doctrine here is called Seminole Rock, or AUR, A-U-E-R, not O-U-R. The basic test is the court will defer to the agency's interpretation of its own regulation as long as that interpretation isn't completely wrong, completely erroneous, completely untenable. If it's even within spitting distance of the sort of what you think the meaning of the regulation is on its face, the court will basically defer to it. Similarly, the agency can flip-flop on interpretations. They can interpret the regulation one way, and then the next administration can reverse course with minimal procedural requirements. That was a case that was decided this year, just a couple of months ago, I guess, called Perez v. Mortgage Bankers, where the court said that the agency didn't need to go through notice and comment before reinterpreting a regulation. The agency doesn't actually even need to go through notice and comment to foster its initial interpretation. Like Adam said, interpretive rules don't go through notice, they don't have to go through notice and comment. In fact, the agency doesn't even need to offer its interpretation ahead of time. You can be in a case against an agency, or you can be in a case involving a regulation, and the agency can come to court, file a brief saying, here's what we meant by the regulation, and generally, the agency gets the same utmost deference from the courts in interpreting that regulation, even when it's an after-the-fact interpretation. Now, let me put this in perspective. There's been a number of studies in recent years trying to quantify what the upshot of this deference is. How much do agencies win or lose when these deference doctrines are in play? In Chevron cases, where you're talking about deference to an agency's interpretation of the statute, and if you're interested in seeing any of these studies, just email me. I'll send you the law review articles. No one ever takes me up on that invitation, actually. But to put it in perspective, in Chevron cases, in both the Supreme Court and the lower courts, the agencies will win about 70% of the cases if Chevron deference is at issue. If you're dealing with interpretation of a regulation, so Seminole Rock or our deference, the lower courts tend to rule in favor of the government in about 75% of cases. In the Supreme Court, it might be as much as 90% of cases the agency is going to win if they're interpreting their own regulation. In addition to those statistics, the federal courts compile their own statistics on wins and losses in court. In 2014, the D.C. Circuit, which hears so many of these cases, they decided about 378 cases coming from agencies. And according to their statistics, the agency was reversed in 16% of those cases. Nationwide, the federal courts heard about 7,500 agency appeals, and the courts reversed the agencies in 13%. Now, let's be clear here. Much of the time, the government wins because it's just right. You know, the government the executive branch doesn't get everything wrong, and so oftentimes they deserve to win. It's not just because their thumb is on the scale because of deference. And oftentimes the courts do push back against agencies, especially in some high-profile cases. We saw this last year when the Supreme Court pushed back against the EPA's climate change regulations, Utility Air Regulatory Group against EPA. Hopefully, personally I say, hopefully the court will do the same thing in the King v. Burwell healthcare exchanges case and push back against agency interpretations. But again, more often than not, deference is a major, as Robert said, a powerful weapon in the agency's regulatory arsenal. Now, at the Supreme Court, there are justices openly questioning some of these doctrines in recent years, especially with respect to our deference, the deference that an agency gets interpreting its regulation. Beginning with Justice Scalia in a 2011 case, he started asking, is it really right that the same agency would write its own law and then get free rein to interpret it? At least with statutes, Congress writes the law and then the agency interprets it, so there's a bit of a check and balance. Here you have the same body writing and interpreting the law. And so Scalia has begun to push back against this. He's received support among some of his colleagues to a greater or lesser extent, Thomas, Alito, Roberts, and Kennedy. There seems to be an openness among those justices to at least reconsider this deference doctrine, if not overturn it completely, but that case hasn't arisen yet. It really came to a head this year in the mortgage bankers case, which I alluded to earlier. The court had to decide whether an agency needed to go through notice and comment before changing its interpretation. The court said no. And a number of the justices, the conservatives, even while they agreed with that ruling, they said, this shows how ridiculous the situation is. The agency doesn't have to go through any process ahead of time to make these interpretations or revise them. And then we're going to turn around and give them complete deference on the back end of the process. It's really inappropriate for an agency to get such leeway at the front end or the back end. There needs to be an ex ante or sometimes they say there needs to be pay me now or pay me later, basically. You can't have both of these doctrines, and so the justices seem to be pushing back on the deference. And this noise coming from the Supreme Court may already be having its effect. A recent study showed that the lower courts are deferring to agencies less now in interpreting their own regulations than they did before Justice Scalia and the others started criticizing the doctrines. So there has been a beneficial effect, but these doctrines still stand. Now, there's talk of possible legislative reform, maybe a broad statute to take away Chevron deference. In theory, there's a basis for that. Chevron deference, the court says, or has said over the years, is about congressional intent. The Supreme Court presumes that Congress intends for the agencies to basically fill the gaps in statutes through interpretation. And so if the basic premise of Chevron deference is Congress has delegated this power to the agency, well, then Congress could take it away, could take away that deference. But it would be dangerous to put too much emphasis on that strategy. Even if you take away deference, the formal deference doctrines, if judges have a deferential mindset, they may well reach the same decisions even without the name Chevron deference or our deference. Again, look back at those statistics. One of the studies showed that even where courts said they were applying much less deference or no deference, the agency was still winning 60% of the time versus 70% of the time. So we're really talking about a small change, practical difference in those doctrines. If the judges are of a deferential mindset, legislative rescission of Chevron may be sort of like pushing on a rope. You're not actually going to get where you think you're going. Underlying all of these problems, really, it's not just about deference. The real problem is the initial delegation of power. Again, like I said at the outset, Chief Justice Roberts said, congressional delegations to agencies are often ambiguous, expressing a mood rather than a message. And this is what makes Chevron, in his words, a powerful weapon in the agency's arsenal. When Congress grants such broad powers to the EPA or to the FDA or whichever agency you might have in mind, there's so much room for interpretation that it's very difficult in many ways for the courts to really exert a check and balance on the agency's overreach, except in the most egregious of cases where the statute is plain on its face, such as, again, last year's climate change decision, maybe this year in the healthcare exchanges case. Now, all of what I've just discussed is what happens when you get to court. Increasingly, one of the real dangers in the relationship between the agencies and the courts is that too many disputes don't get to court in the first place. And that's what Boyden's going to be talking about.
Yeah, I want to make another point about the relationship between deference and delegation, which makes it hard for you to correct the problem, in addition to it being like pushing on a string, and it's a judge-made doctrine to begin with. Because it's a reflection of the failure of Congress to be more specific. It's putting the courts, putting the courts in the position of trying to correct, in a sense, Congress's own mistakes, and asking the courts to correct. And is there a moral hazard there where if you think you've solved the problem and the courts are given more authority, you may have ended up encouraging even more broader delegations? I don't know. It's just something to keep in mind. It's better if Congress speaks clearly and avoids these problems to begin with. Judicial review is very, very important. Leave those issues aside. It's what makes anything enforceable. When I first started here in Washington, I don't know how many years ago, I can't say, won't say. The first thing you did when you saw a new statute was to flip to the back and see whether there was any judicial review. Because if there wasn't, you didn't have to worry about it, and you'd throw it in the trash basket. And even now, if you look at an EPA rulemaking, they'll be at the end of the preamble compliance with other laws, and they'll list 5 or 6 or 7 other laws, a paragraph each, none of which have to be paid attention to because they are they're not judicially reviewable. The Data Quality Act, a great promise, would have kept the agencies like the EPA really on the ball in terms of following science religiously and carefully, but it's not reviewable, and so it doesn't have any teeth. And when you can't review, and all of the changes that would be made, could be made to the Administrative Procedure Act. There's a lot of activity, witness this session. There's activity in the Senate to try to figure out how can we tighten things up. Again, if those improvements, rewrites, aren't judicially reviewable effectively, they don't mean much. And why is this happening? Judge Ginsburg once asked me on a long trip that we were taking, was in a car. He said, how come it is in the period of the most explosive regulatory output ever in American history? He may have been exaggerating, but the point is a lot of regulations, a lot of Dodd-Franks, Obamacares, is our caseload falling. And even before 3 extra judges were added, the D.C. Circuit had the lowest caseload of any circuit in the nation. Now, why is that in an era of exploding regulation? And that was not the case, of course, when I first came here to Washington. And I think the reason is because the agencies have gotten so much power, continuous power, that they are able to intimidate, blackmail, cajole, threaten litigants out of litigating. And there are lots of examples of this, and the more examples you can collect and make known to your bosses and make known, therefore, to the public, I think the more attention you will get for everything you're doing. Because this is something the public can really understand. And Senator Langford, new senator, used to be in the House, new senator now from Oklahoma, told me the other night of a story of a fabricator, steel fabricator, that had no emissions. The parts that they were fabricating had upstream emissions, which were reported, but they were just putting them together, no emissions. They never filed anything. EPA threatens a $5 million fine for failure to file these forms. The company says, but we don't have anything to put in the forms. We don't think the forms apply to us. Oh, yes, they do, $5 million. And the company says, well, we'll sue you. And EPA says, okay, we'll drop the fine to $500,000 if you promise not to sue us. Now, that's just a shakedown, but that's the way it works. When you get into all these permitting, one of the dreams of EPA has been to be like the FDA, pre-approval for every major puff of smoke. And rather than looking at it afterwards, you have to get a Mother May before. And that is open season for intimidation and threat. The most sweeping example of this is, and this is public record, what I'm about to tell you, all of this is public record, but this is really clearly in the public record. If you go and read the preamble to the final rule on the corporate average fuel economy CAFE standards, the agency quite proudly announces that it's gotten all the car companies to go along, and then cites to the letters where the car companies make the commitment, and the commitment is set forth very clearly in one letter by Ford. Ford agrees not to challenge anything about the CAFE regulation until the midterm review, which is beyond Obama's tenure. In other words, for 8 years, we will not challenge anything to do with that you do to us in the realm of fuel economy, which is the main thing. And we'll do that if we aren't forced to make a California car that's separate from the other California climate change car that's separate from your car, the government car, or our car. And that was the dynamic. Working with California Resources Board, an easy thing to do since Mary Nichols, the head of it, used to work for Cal Browner in the EPA. They agreed to threaten a California car, which requires a waiver, and then agreed that if the car companies complied with the new White House regulations, that would stand as compliance for their regulation. Only after the car companies had agreed not to challenge any of it. And so it puts the car companies in a big box, because there are lots of issues, like any negotiation or any treaty or any contract or any rule. There are questions that come up that weren't thought about or that are disputed or aren't clear. That's what we're talking about here, is Chevron and whatnot, in areas where it's not clear. But basically, that review is denied too. Now, there's nothing binding about these letters of restraint and forbearance. There's no way EPA can go into court and enforce these letters. That would really make it look as difficult and as silly as it is. But people subject to this kind of pressure generally don't challenge it, because the agency has so many things they can do that are not nice. So people tend to pull their punches and not sue when they could. When I first came to Washington, unthinkable that an agency would put pressure on you not to challenge a reg that they had just issued. It was unthinkable. And when I served in government in the Reagan-Bush years, which is now 25 years ago or so, if we ever caught a bureaucrat in any of the agencies doing this kind of thing, I think we would have fired them. And there was one example with the FDA. I don't know whether you remember this, but one question about FDA yanking not a drug company, but well, it was a drug. And Dingell got a hold of the information that the drug company was being intimidated. We will not approve your drug. Actually, it was a device. We will not approve, or will stop approving your devices unless you do X, Y, and Z. And I wish I could uncover that letter, but Dingell, and I think it was Broyhill was the ranking member at the time. You all are too young to remember who Broyhill was. Hopefully you remember who Dingell was, or is. The letter threatened criminal penalties if they caught anybody at FDA making that kind of threat. So that was the attitude 25 years ago. Today, it's expected that the agency will, and Hester, who just appeared, said, quoted a colleague as saying, how dare some securities firm challenging the government, when that was commonplace 30, 40 years ago. So this is a big problem. The more anecdotes, like the ones I've told you, the more of these that the public can understand, I think the better off you are laying the groundwork for getting good change in the regulatory setup. There's a lot about the Administrative Procedure Act which is good, which is, you know, even puts me to sleep, even though I think I know it. And if it's going to put me to sleep, it's surely going to put somebody on the street asleep. And so you have to come up with anecdotes, and in order to make the public understand what you're really after. And I use as an example always an ad that was run back in 1980 by a senator. OSHA just issued a rule to the effect something like you now have to have potties every 500 square yards of ranch, or not maybe square yards, square miles. And so I mean, really, how stupid can you get? And so this clip showed a Marlboro guy, you know, big hunk, riding a beautiful steed, dragging behind him a little potty. And if you saw it once or twice, you just couldn't stop laughing. And that tends to help bring this down to earth. It's not the only thing you have to do. You have to come up with proper solutions to these problems. And that's difficult. But in order to identify the problem, like identifying the problem in any law school exam, that's the first step. And to educate the public about what's needed. That was done in the late 70s. And Reagan had a lot of wind at his back when he came into office. He campaigned on it to boot. He was a great anecdote, great storyteller. But it made a big difference back then, and I think that it can make a big difference now. So I'm saying, be clear in your legislation. If you hear about a constituent being scared of taking on judicial review, that, you know, seeking judicial review is now been converted into, you're suing the agency. It's not really. It's provided for by statute. It's routine. It's not something you're doing to punish the agency. It's accepted, was an accepted part of life. And then if you get good anecdotes, please collect them. I think Langford's got Senator Johnson have a website that's going to collect. Maybe we have one over here in the House. But I think we need the anecdotes. You need the anecdotes to illustrate the problems you're talking about to the general public. Thank you.